Good morning, Liberty. It is Wednesday morning, July 10th, 2019. My name is Michael Boldin, broadcasting live from my home office and studio here in downtown Los Angeles for the 10th Amendment Center. We do this broadcast every single Monday, Wednesday, Friday at 9:30 a.m. Pacific time through our channels at YouTube, Facebook, DLive, Periscope, and Twitch. We have podcast versions and other archives of all of our shows over at 10thamendmentcenter.com/Good Morning Liberty. I think we have an interesting show today. We're going to be talking about Obamacare, which was actually back in a federal court again yesterday. You might be thinking like, oh man, I thought that went once, twice, maybe three times. How is this still going through court? Now, first of all, I should add the disclaimer that my view on Obamacare, the Affordable Care Act, affordable in quotes, is that it was unconstitutional the day it was signed. If we take the position that any act against the Constitution is void, then that's my view of Obamacare. That's what I've held it to be all along. But a lot of people are very interested. It's still being enforced by the Trump administration. It was enforced by the Obama administration. A lot of states are participating heavily and helping effectuate it. So, of course, whether we understand that in principle it's unconstitutional or not, it is still in effect, even without the so-called individual mandate tax or penalty, because a lot of the worst and most onerous regulations still exist. So there is now a court case that I think you guys are going to find very interesting if you haven't heard much about it. So I'm going to go over what's going on in that court case, explain what's being debated, what the ramifications are for the ACA. And then I'm also going to talk a little bit about some things that should be done that haven't been done in wide numbers on the state level, because we don't know what the federal courts are going to say about it. They often approach this from a political standpoint, even though they claim that they're looking at the so-called law, or even when they look towards the Constitution or the founders, they still look at, well, how much impact will this have on the day-to-day operation of a particular market if we strike it down? So there is a political question. The court is a political beast, so we cannot rely on them. So I'm going to go over some steps that can be taken to deal with Obamacare, whether the courts do the right thing or not. Now, before getting to that, I do want to say hi to my friends out in the live chat. I really appreciate everyone who joins me in the live chat. And even if you can't make it, I love that you are willing to spend a little bit of your time with me today. I'm very, very grateful for that. So over in the live chat, YouTube, Justin Bayola, good to see you. Ward Lawrence, Sabolytic, I don't know if I pronounced that correctly. David Smith, not Dave Smith, but David Smith, good to see you. And Christ Saves, and a few others over on Facebook. Dan Reed, Justin Morrison, Kenneth Springer, Jennifer, Clay Davis, Donnie Smith, and a few others. If I've missed you, I apologize. I am grateful for everyone joining me, whether here live or in the archive. I think this is going to be an interesting program today. So let's get into the news that I want to cover. First, I'm going to go right to the mainstream. Of course, if you read through all the articles, you're going to get a lot of propaganda garbage. There was an article from Vox that I thought had some interesting insight to it, but the rest of it was talking about how horrible it would be. It was clearly an editorial piece, even though it was supposed to be news, but that happens on all sides of the political spectrum. So let's first take a look at what's going on over at CBS this morning. Appeals court appears ready to rule Obamacare unconstitutional. Again, all these links, most of them should be in the show notes over at 10thamendmentcenter.com/Good Morning Liberty. I published that about 30 minutes to an hour after the live show is ending. So if you're watching live, you can go check that out a little bit later. So this was published this morning, 8:17 a.m., probably Eastern time, so a few hours ago. The Affordable Care Act, they write. There's not an author listed to this. Maybe it's AP or it's just CBS reporters. And the Affordable Care Act and the health care coverage of millions of Americans could face a major threat to its future. That in and of itself is also a piece of propaganda. I would say that health care will be far better without government involvement, but that's a separate show. A federal appeals court in New Orleans, they go with, appears ready to rule that a core provision of Obamacare is unconstitutional. And actually, that is an understatement, and we'll get into what's going on. they're not just looking at whether one piece of Obamacare is going to be seen as unconstitutional, but whether they should strike the entire act down, have an opinion that the entire ACA is unconstitutional. I take that position. Does the court agree with me? At least one judge has already taken that position, surprisingly enough. It was I think it caught a lot of people off guard last year when this judge actually took the position that the entire ACA was unconstitutional. Not for the same reasons that I do, but nonetheless, still a positive result. So they go on, they say the Supreme Court previously ruled that the Affordable Care Act was constitutional. And I hate that they use the term ruling because the Supreme Court doesn't issue rulings. Even at the top of the paper, it says an opinion of the Supreme Court. And that's one of these things that I like to really nag on. I can't say ruling without pointing that out. But the Affordable Care Act was constitutional because Congress has the power to tax people. This was a very creative approach, and it was only Justice John Roberts that actually took that position. It held, and I'll get into explaining that. For those of you who've always wanted to understand how this played out, too, I'll get into a little bit of that in a bit as well. It held that if people had to pay a penalty for not buying insurance, that payment was effectively a tax. Okay, and then let's look over here at the NPR. Affordable Care Act is back in court. 5 facts you need to know. I'm not going to cover all of them because most of them are junk, but this is what's going on. So the reason that it's in court. So we know that NFIB versus Sebelius. This is the famous Obamacare case. Justice Roberts came up with this really creative approach and said, even though they don't have the authority under the Commerce and Necessary and Proper Clause, they already took the position that they can't do this mandate under the Commerce and Necessary and Proper Clause. And mind you, I don't take the position that just the mandate is a problem. You can get rid of the mandate and you still have mounds of unconstitutional regulations that shouldn't exist in the first place. This is not something that was delegated to the federal government under the Constitution, reserved to the states or the people as they decide, not the feds. And so this was already held up as a tax, part of the taxing power. Very creative by Justice Roberts, and really a huge stretch, totally wrong. But then in 2017, Republicans passed this tax bill that eliminated the penalty included in the ACA for failure to maintain health insurance coverage. That's how they report it over at NPR, and that is correct. The lawsuit, Texas versus United States, was filed in February 2018 by a group of Republican attorneys general. I think it's Texas versus Azar. Well, was filed in February 2018 by a group of Republican attorneys general and 2 governors. They argued that since the Supreme Court had upheld the ACA in 2012, specifically because it was a valid exercise of taxing power, taking the tax away makes the entire rest of the law unconstitutional. Last December, they go on, Judge Reed C. O'Connor agreed with them. And he writes, in some ways, the question before the court involves the intent of both the 2010 and 2017 Congresses. The former, he wrote, enacted the Affordable Care Act. The latter sawed off the last leg it stood on. So he's taking the position, this Judge O'Connor took the position that without the tax, if supposedly the only reason that the mandate can exist is with the tax, without the tax, the mandate has to go. Unquestionable. But where I think a lot of the so-called legal experts really went nuts, they like panned across the political spectrum. A lot of people who actually were filing briefs against the Obama administration, so-called conservative legal commentators, were attacking Reed O'Connor because Reed O'Connor said without the mandate, the entire act doesn't exist because the mandate is what makes the entire act supposedly exist. And if you have to strike that down, then it is not severable. This is the legal term. We can't sever the mandate from the rest of it and just strike down part of it. We have to take the position that the entire act is unconstitutional. Now, like I was saying, they're getting to it's unconstitutional from a different direction than I am. I think, and I hold the view, that they don't have the power to have all these regulations over the health industry in the first place. They don't have the power to be funding things and taxing people. They don't have the power to do an individual mandate. None of it. But if they get to it kind of roundabout, I would be happy if that is actually how it plays out. I don't trust that it will happen, but I think it's very interesting to take a look at it. One of the people that I think is really, really good to read on this is a guy named Randy Barnett. And if you watched Monday's show of mine on the Commerce Clause, Barnett is actually one of the leading experts alive today on the original legal meaning of the word commerce. He's studied thousands and thousands of examples from the founding era on what that means. This is a top constitutional lawyer. He was one of the lead, part of the legal team that actually was seeking to overturn Obamacare in the original case. He was also the lead attorney, or maybe part of a team, in the famous Gonzalez versus Raich case, the 2005 Commerce Clause case on medical marijuana that the feds won as well. And he writes here, this is over at the Volokh Conspiracy, which is now hosted over at Reason. Therefore, there was a degree of vindication when in NFIB versus Sebelius, 2012, 5 justices entirely endorsed the commerce and necessary and proper clause analysis we had formulated in 2009. Of course, in NFIB, the court ultimately upheld the Affordable Care Act when Chief Justice Roberts alone, this was Roberts, this was not anybody else, Roberts alone invoked a, quote, saving construction. In other words, he read the act in a way that no one else read it and looked at the penalty enforcing the requirement to buy private health insurance as a tax. So Barnett goes on, says the Chief Justice held that because the penalty could be construed as a tax, the ACA could be upheld. So this is very, very interesting. And I guess I was wrong. The case is Texas versus U.S., and Barnett goes on. In Texas versus the United States, a single district court judge, Judge Reed O'Connor, has accepted the argument made by state attorneys general because the Tax Cuts and Jobs Act of 2017 zeroed out the so-called penalty. It is no longer fairly possible, and that's how I believe Roberts put it, to construe the penalty as a tax. So the penalty no longer fits the definition of a tax that Chief Justice Roberts described it as. And so it doesn't exist. And so then taking it even further, instead of just striking down that part of it, O'Connor then held that since the insurance requirement is now unconstitutional, which we know all along, but finally a judge agrees, and was inseverable from the rest of the ACA, then the ACA in its entirety is now unconstitutional. So at least one federal court has taken this position. And now, just yesterday, the case was in, I believe it was an appeals court, Fifth Circuit Court of Appeals. They heard oral arguments yesterday to determine a few things. One, and I'm not going to get into this, whether the court even has standing to hear this. This is kind of legal mumbo jumbo, and I don't think that's really going to be a question. There are a lot of interesting law review posts and things like that. If you want to read up on it, go for it. I don't recommend it. It's pretty boring, and I think the end result is the court is going to take a position on it one way or the other, rather than saying we don't have any say in it, and so then O'Connor, it's up to O'Connor. It can't get any further. But the other things that they're actually really debating is, one, whether this view that without the tax, the mandate is unconstitutional, and then two, even bigger than that, and I don't think there's a lot of opposition that really holds much water on that, or practical water. Not, again, clarify, none of it is constitutional. We're just talking about how I see, or how the so-called experts see it playing out in court. I don't think the court is really going to reject that view. But the big question is this severability. And a lot of legislation, for those of you who've never read legislation, whether on a state or a federal level, there is often what's called a severability clause. And in it, it'll say something like, if any part of this act is held to be unconstitutional, the rest of it is still in effect. So they're actually taking the position that each piece of the act, each section of the legislation, mind you, Obamacare is massive. How many pages of paper would that have to be on to print it out? It's huge. So they actually went out of their way to not include it, because it's such a common practice to include a severability clause. The fact that they didn't include one tells you that the Congress of 2010 did not intend to have any part of the act to be inseverable. It was an all or nothing kind of proposition. And I feel like that's what it was sold to everybody as well. And going a little bit further here, this article, again, really interesting. And Barnett did a whole series of articles with Josh Blackman, who is another leading legal scholar on this issue. He goes on a little further. In our view, the individual insurance mandate in Section 5000A did not become unconstitutional when the penalty was reduced to zero. And this is what I like from Barnett. It had already been held to be unconstitutional by 5 justices in NFIB versus Sebelius back in 2012. He actually is pointing out that in that particular case, they're already saying you can't do it. Chief Justice Roberts wrote, quote, "Just as the individual mandate cannot be sustained as a law regulating the substantial effects of the failure to purchase health insurance, neither can it be held as a necessary and proper component of the insurance reforms. The Commerce Power thus does not authorize the mandate." This was in Roberts' opinion upholding it. And that's why they call it a saving construction. It's like a Hail Mary at the very end. They're saying you can't have this even under, mind you, their view of the Commerce Power and the necessary and proper clause power is extremely expansive. And even under that, that's how bad the Affordable Care Act is according to the Constitution. It's so broad and so awful that even under current Supreme Court jurisprudence, all the precedent, even then they're saying, well, we can't justify it under the necessary and proper or commerce clauses. We have to come up with the saving construction of calling it a tax. So he goes on. Roberts rested his reasoning on a saving construction of the penalty as a tax. He, and he alone, justified adopting this construction on the ground that the insurance requirement or mandate was unconstitutional. And he wrote, and you can see it in here as well. He says, without declaring the Commerce Clause question, I would find no basis to adopt such a saving construction. So this was really a reach. We all know it was a reach. But now, as Barnett points out, we can't even read this section as a tax because it's been eliminated. Once it's zero, there's no more tax. I mean, unless somehow a taxation is theft means taking $0 from you as they're stealing, they're not actually taking any money or demanding people hand it over. And Barnett points this out as well. He says, however, if the penalty in Section 5000AB can no longer be read as a tax, then neither can 5000A as a whole. And because of the holding of Chief Justice Roberts and the 4 other conservatives, the mandate in 5000A was and still is unconstitutional. The mandate was declared constitutionally dead in 2012. It has always been unconstitutional, even before the Supreme Court took that position. It's always been. And so is the tax penalty. But of course, again, the big question is, what's going to happen in court now that O'Connor has said this mandate is so essential to this Affordable Care Act? I got to strike the whole thing down. And that's the big question. A lot of people, most of the legal scholars, even the so-called good ones, are wishy-washy at best. And Barnett, I think, is pretty good on this. Oh, I think I forgot to have the screenshot up. Sorry, I switched out. And he says, was Judge O'Connor correct to conclude that the unconstitutional insurance mandate is inseverable? And if it is inseverable, if you strike down one part of it, then the whole thing is unconstitutional. He says, speaking solely for myself, because the law of severability is not my area of expertise, I'm more hesitant to offer a definitive opinion. So maybe he hasn't studied it a lot, but he has some interesting thoughts. And I'm going to point out something else that's interesting as well here in just a moment. He says, on the one hand, Congress declined to include a standard severability clause in the Affordable Care Act. I mean, this is pretty obvious. We know that they have the option to do this. They do it all the time. But when they pass something, in general, when they pass something where they want the whole thing all or nothing, that's how Congress communicates this. So if you look at the way the courts look at a particular case, this is a big deal. The fact that they did not include this. They could have, and it would have been signed. It probably would have passed even easier, but they were so pushing this mandate part of it. Without the mandate, how can you have anything? We were sold this so aggressively. We know that's what they intended to do. Now, under current doctrine, Barnett writes, the failure to do so, to include this severability clause, requires the courts to answer a difficult counterfactual question. Was the unconstitutional provision so essential to the remainder of the act that Congress would not have enacted the entire statute without the unconstitutional provision? It's hard to say. I don't think they would have, personally. And he was part of that litigation in 2011, 2012, for that whole case. That whole legal team, he writes, contended that the individual insurance mandate was expressly deemed by both Congress and the government to be essential to its broader regulatory scheme. I know I read about it over and over. Without this mandate, if you don't force people to pay a penalty, then they're not going to get involved, and then the whole system's going to collapse, and millions of people are going to die in the street, that kind of nonsense. We were told this type of thing over and over and over. And as I mentioned at the beginning, earlier, Barnett was also part of the Gonzalez versus Raich case. And this was the case. And if you want to read this, and I'll give a brief overview here from what Barnett had to say. But the Obama administration actually took the views of Justice Scalia in that 5-4 opinion, saying that a plant grown in your backyard, consumed in your own home, never brought across state lines, never entering into commerce, was somehow fell under the Commerce Clause. And so the Obama administration took that so-called conservative argument, which was just junk under the Constitution, and used it to argue that the Affordable Care Act was constitutional. And Barnett gives an overview of how this kind of played out. They said this activity was economic in nature according to a 1966 Webster's Dictionary definition of economic. And if you've heard me talk about how to actually understand constitutional terms, we know that the Constitution is a legal document. It is a contract or a compact. It is a legal document, however you want to describe it, but it is something for law. And like any legal document, the meaning of that document is the same today as it was the moment it was given legal force, and that is ratified by the people of the several states. So to understand the meaning of a term in the Constitution, you have to understand what those words meant at the time it was ratified. Words change quite a bit over time. If you were to compare Samuel Johnson's Dictionary of the English Language in 1792 or in the 1780s to a 1966 Webster's Dictionary of Economics, it could be absurdly different. I don't know. I haven't compared it. But the fact that the Supreme Court in 1995 or 2005 was relying on a Webster's dictionary from the 1960s to back up its position, and this was Scalia signed on to this as well, is real bad. And it played out, and as we see, we're still sitting around waiting for the courts to tell us to live more free, which is a bad strategy in the first place, and I'll get to that a little bit more in a bit. And Barnett goes on, he says, according to this doctrine and according to this case, Congress can regulate even non-economic activity if doing so is essential to the broader regulation of interstate commerce. And so that's the position that they took in this Obamacare case, this Justice Roberts travesty. And he goes on, he says, in NFIB, both Congress and the executive branch contended that the mandate was constitutional under this rationale of Raich because the individual insurance mandate was essential to the ACA's broader regulation of interstate commerce. And the reason, this is the reason that this is important, and I know it might be convoluted and it's a lot of legal jargon that I don't think you and I really give a damn about in our day-to-day lives. It's a lot of behind-the-scenes power structure junk. But it's important in this particular case because this addresses the severability issue. In court, the Obama administration and Congress took the position in court that they were saying They were using this Raich rationale, and they were allowed to regulate non-economic activity because it was, quote, essential, their words, to the Affordable Care Act. And so if the mandate is essential, it really means that the act doesn't stand without the mandate. So it is the court's job, even though the act never should have passed, and the state should have taken action to nullify in various ways. And I'm going to cover some ways that they can chip away at it still, because I don't think we can trust the courts on this. But the court should take the position that even the government itself, even the supporters of the act when Obama was there, took the position that the mandate was essential. So if it's essential, it is an essential part of the act, and striking down the mandate means the rest of it should go as well. So that's my view, and I think Barnett seems to take that position as well, that it shouldn't be seen as a standalone piece of the Affordable Care Act. Now, one of the very few legal scholars, and this is a guy that I've talked about many times, Rob Natelson, one of the few legal scholars that actually supported O'Connor on this is Rob. And in January, he wrote an article in defense of the court decision striking down Obamacare. It's relatively lengthy, but I've highlighted a few pieces that I think really shines a light on this. And he even said himself in this article, like most commentators, I initially questioned Judge O'Connor's non-severability decision, but his 55-page opinion thoroughly buttresses it. This is not just I don't think O'Connor came at this personally. I don't think O'Connor came at this from a political approach. I think this judge literally looked at the case law and applied it properly. And Rob goes on, he writes, the judge's opinion shows that the ACA itself affirms explicitly and repeatedly that the mandate is essential to the law. And if the mandate is seen by Congress that it is essential, that you can't have the law without the mandate, then the whole thing has to go, without a doubt, according to this court case. And he goes on, he says, one example is Section 1809(12)H of the ACA that states that, quote, the requirement, this is the mandate, the requirement is an essential part of this larger regulation of economic activity, and the absence of the requirement would undercut federal regulation of the health insurance market. I mean, to me, it's pretty cut and dry at that point. Maybe somebody has some reason to explain why they didn't mean this. I'm sure anybody can make an interesting legal argument on it, but in the act itself, what Congress passed specifically says this mandate is essential to the entire broader regulation of the health insurance market. So without that, again, I see this as non-severable in this court case, and I also see the act should never have been passed in the first place. Rob is very clear. He says functionally the entire ACA revolves around the mandate. It forces people to buy health insurance, giving insurance companies and healthcare providers more revenue. The added revenue enables the companies and providers to pay for the new taxes and regulations. So without the mandate, without the penalties, without the additional revenue, without the so-called tax, the act doesn't exist. And Judge O'Connor also noted in his 55-page opinion, which you can read if you want, it's linked in this article here, in the 2012 ACA case, all 9 Supreme Court justices admitted the tie between the mandate and the rest of the law. So anyone who, now if this gets to the Supreme Court, if this appeals court actually kicks it to the next level, it'll probably get to the Supreme Court just in time for the 2020 election, which means that it's going to be a political decision, a political opinion, and maybe there will be another saving construction by Mr. Roberts, or maybe Alito will step in this time and write for the majority. And they'll say, well, you know, those 9 Supreme Court justices, including myself, well, that's not really what we meant. And it really wasn't part of the entire act. The mandate wasn't essential, and we meant something else. And it's possible they'll do that. They did that with the tax part of it. It's the penalty/tax. So I don't know. So what should be done? I mean, this is very interesting to watch, and I will certainly cheer the court system for doing something right if it does something right. Justice O'Connor, or Judge O'Connor, I'm not sure what the name, Judge O'Connor, not Justice, Judge O'Connor, I think, did the right thing in this very lengthy, interesting, well-thought-out opinion based on the case at hand. But states should actually stop participating. Unfortunately, the states are heavily participating in the Affordable Care Act. Even ones that were not when Obama was in office have flip-flopped. Idaho, I'm looking at you, for example. But there are a number of things. And I'm going to look at this article here from Mike Meharry that we ran in July of 2017. It's basically a republication or reworking of many articles that we've published over the last almost 10 years, basically laying out the steps that states should take to stop participating in this federal act, making it more difficult. The more difficult it is for the federal government, they couldn't even get a website up and running in the early days of this thing. How can they run the entire health market? Only with the help of the states. And Mike points out the ACA was predicated on state cooperation. The federal government was never intended to run this healthcare system alone. And under the Constitution, it wasn't intended to do any of it at all. Ultimately, he says it can't do it without state help. It even tried to compel states to expand Medicaid under the act. That was part of the Affordable Care Act. Originally, they were requiring states to implement and expand Medicaid. But we know under the anti-commandeering doctrine, which I've talked about many times on this show, I've covered in speeches, we've covered in many, many articles. Mike Meharry and I and others have covered this over and over and over. And I believe my buddy Joe Wolverton is doing a book on Federalist 46, James Madison, which is the constitutional basis for this doctrine, that you cannot require states to do stuff, to implement or enforce federal acts or regulatory schemes. And so when the federal government tried to require states to do this, even the Supreme Court was like, man, that's too far. We're not going to require them to do that. So expanding Medicaid is optional. So states should not do it. They should kick the ball over to the federal government, which doesn't have the resources to do it in all the states. West Virginia did this in 2016, for example. And there's a handful of other states that have taken this step, saying, we're just not going to expand it. You guys figure out how to do this. But states can go a lot further, Mike points out, and Judge Napolitano, I think, is a good friend of the Constitution and liberty. He said a few years ago that if a number of states were to refuse to participate in Obamacare in a wholesale fashion, that would, quote, gut Obamacare. And this is how he put it. It will gut Obamacare because the federal government does not have the resources or the wherewithal to go into each of the individual states. Obviously, I want the thing gone. But the way to get from point A, where it is now, in almost full effect, to point Z or point B, whatever point you want to call it, it's not happening in one fell swoop. Maybe we'll get lucky after 9 years, finally, that the courts will take that position. I don't really expect it, to be honest with you. I expect at best a half-assed kind of partial or maybe another saving construction. I'm cynical at this point, so I do not trust the courts to actually end this thing. But we'll see what happens. If that happens, great. If not, you don't wait till later to take a response to it, because then you've just entrenched the act even further. States should be doing this right now. Basically, they should be passing legislation that bans enforcement or implementation of the Affordable Care Act. One of the ways is to ban insurance commissioners from actually doing enforcement. The federal government HHS does not have an enforcement arm to deal with supposed infractions for example, insurance companies that maybe are offering plans that are not compliant with the Affordable Care Act. Cheaper, catastrophic, whatever it may be. If they offer plans that don't fulfill all the so-called requirements, add all these other pieces of insurance that make it unaffordable for all of us, then it's up to the state insurance commissioner to cite that company to go in and do the enforcement action. So if you simply ban your state Department of Insurance, DOI, or insurance commissioner from doing the enforcement, it becomes much more difficult for the federal government to pull it off. Now, Idaho actually last year took a step in this direction. I don't know how this played out, to be honest with you, and I apologize for not having done all the research needed to understand exactly how this has played out. But early last year, in January of 2018, Idaho Department of Insurance Director Dean Cameron released details of a new plan where they were allowing health insurance companies to offer less costly plans that don't comply with Obamacare. Supposedly, these health insurance companies aren't allowed to do this at all. So they were basically allowing things like insurers can now cap their own costs at $1 million per year per individual, can charge customers separate out-of-pocket maximums for different services. They can offer plans that deny coverage for pre-existing conditions. They will no longer required to cover pediatric, dental, or vision care. I mean, I'm not having a kid. If I have insurance, why do I have to pay for pediatric, dental, and vision care? Because this is a socialist plan. You don't get socialism unless you're really pushing for everyone to pitch in and pay for something. Required government charity that drives up the costs and lowers the quality. So Idaho actually came out with this approach early last year. Unfortunately, the Trump administration was pretty aggressive about this. They sent letters their way just 2 months later. March 8th, Centers for Medicare and Medicaid Services Administrator Seema Verma sent a letter to Governor Otter, who was the governor at the time, and Idaho Department of Insurance Commissioner Cameron, saying that if the state does not enforce some Obamacare requirements, the feds will. I don't think the feds could do this in every state. They don't have the manpower. They could maybe target it like they've done with cannabis, for example. They could go after a little bit here and there. But when a lot of states actually say we're not going to participate, and a lot of businesses say we're not going to participate, and a lot of people buy from those businesses, look what's happened there. So the same type of approach, it looks like Idaho at least was trying to do this. I don't know if they backed down on this particular issue. Maybe someone who lives in Idaho can tell me. I'll check in the live chat here in a moment. I know this is kind of a long show today, but it's really kind of interesting stuff. But unfortunately, one thing that Idaho just did this year was they flip-flopped on expanding Medicaid. That's one of the parts that they shouldn't even participate in. Same with running these insurance exchanges. One of the arguments that people give me is that, well, you know, if the states don't do this, then the feds are going to come in and do it, and it's going to be even worse, and we don't want them doing it either. Without acknowledging the fact that the feds suck so bad, they can't get your mail delivered on time, they don't have enough enforcement power on just about any program, they couldn't get the website up and running on their own, and the administration doesn't seem, even though the administration is doing enforcement actions, I don't think the Trump administration, to be honest with you, is really on board with Obamacare, even if they've done a really, really bad job of ending it. And Republicans in Congress did a really bad job of ending it, although we may have kind of a secret Easter egg with that 2017 act that set up the situation for this court case. I don't think the Trump administration wants to die on a hill of enforcing Obamacare on the states. So this would be the time, not waiting for President Warren or Biden or whoever. This would be the time to chip away at it in the states. Don't expand Medicare. Don't run an exchange for the federal government. Ban your insurance commissioners from enforcing the federal act, so the feds have to do it. And then just stop implementing. So these are 4 things. You could just do the first 3 and it would make it pretty close to collapse. I mean, if Napolitano was saying when Obama was in office that maybe, I think he said 10 or 15 states doing this, large ones, this would gut Obamacare. That would bring it close to an end. And then maybe people would realize that free market options are available. That's my thoughts. I don't know. I hope you guys are finding this interesting. This is, to me, really, really good stuff. Sherman Dye is absolutely correct over on Facebook. The courts were never expected to be the final guardians of our liberty, which is why they were given very little authority by the Constitution. Absolutely correct. And I agree with Sherman here. We shouldn't be waiting for the courts. And if you watched my episode a month or 2 ago on Thomas Jefferson's strategy for nullification, he was very clear when he said in the Kentucky resolutions of 1798 that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Whensoever, immediately. Not after they pass it, after you have some protests, after you vote the bums out, after you sue them in court. No, immediately. And he also said in the original draft of this that a nullification of the act is the rightful remedy. So states should be taking action to nullify this right off the bat, not waiting for one court case and then another court case, King, and another court case, this one. That's not how it's supposed to be done. Christ Save says Ohio has banned it. The problem is people don't hold government accountable to the rule of law. Nappy, Andrew Nappy, we could spend our 60-day session in Florida passing only anti-commandeering legislation and the mandate, and it would be a session very well spent. Absolutely. Janetta Noble Stokes, I agree with you completely. Obamacare does need to be struck down. Thank you for mentioning it was a good show here, Justin. Donnie Smith, read how Florida got rid of Obamacare. Good read. I don't know. Is it actually totally gone? If you have a link to that, Donnie, I would love to see that. I'll check the comments a little bit later today as well. So Donnie Smith is saying that they've gotten rid of Obamacare. I don't know if they've, and maybe Nappy, if you're still watching as well, you might have some insight on this as well. Maybe they've taken steps to not implement part of it, but I have a feeling that, well, I don't know. Hopefully I'm wrong. So taking a look at a few other things, Andrew says, I remember well the endless procession of cadaver trains causing havoc at railroad crossings prior to the Affordable Care Act. Horrible times, right? What's going to happen, Michael Gobin? Nothing as usual. I think you're probably onto something on this, Michael. Maybe the courts will take the right position. But if we haven't been burned on this, wait for the court thing, wait for the new bums, vote in the Tea Party people, we were told. Protest at the Supreme Court, we were told. Vote against Obama, vote for Romney, we were told. Then the next case, then Trump, and it's still here. Obamacare is still here, and the regulations still exist, and they're making insurance costs go up and up and up. I don't have it. I never got it. I guess that puts me in trouble with the penalty part, but we'll see how that all plays out in time. But I don't want to participate in their system, to be honest with you. So we'll see. The LP shared a link to it too this year, Donnie says. Okay, cool. If you have a link to it, please post it here in the comments as well. I will check on that a little bit later. I hope you guys found this really interesting. I think is very interesting to see where this appeals court is going to take it, whether it gets kicked up to the Supreme Court in time or not. Of course, that is very fun and interesting to watch. I like to see the arguments. Some of them are very good. A lot of them are just the same crazy stuff like, okay, they want people to die in the streets. They want to take away health insurance from poor people or whatever it may be. Like they were basically saying in the Vox article that I was originally going to link, and I just couldn't bring myself to do it. So that is all very interesting. But really the bottom line is, if we are waiting on the courts to protect the Constitution, we've taken a very, very bad approach to it. The founders did not tell us that's how we're supposed to do things. We're supposed to stand up for our liberty. We're supposed to pressure our states and local communities to do so, whether the federal government wants us to or not. So again, I hope you enjoyed this. I hope you found it interesting, educational, fun to watch. I appreciate all the comments. Make sure to smash that like button, subscribe, get bell notifications, leave comments in the archives, all that stuff. And if you support this effort, what we're doing, please subscribe as a member, 10thamendmentcenter.com/members. For as little as $2 a month, we make it go a really long way. We'll see you here on Friday. I hope you have a great day, and thanks again for joining me.